Hi, I'm Faye Gersh, founder of the Hemlock Society of San Diego. For 32 years, we've had free monthly meetings to help people plan for a peaceful death. Our speaker today is Kathryn Tucker, a lawyer who for more than 20 years has been at the legal forefront of the Right to Die movement. She will review the historical landmarks that have expanded our rights at the end of life, many of which she was instrumental in obtaining. The Hemlock Society believes in a good life and a good death. Both take care and planning. Visit our website to find out more about our programs and how to join. Thanks for viewing this valuable meeting and for your generosity in helping to continue to educate the public for the next 32 years in San Diego. Thank you. Good afternoon, everybody. We're very happy to have you here. You know, we never meet on a Saturday. We always meet on a Sunday. So this is very nice to know that you will come out on both days. This is a big month for us in Hemlock because we have 3 speakers. 2 of them just happen to be in the neighborhood, like Kathryn. We're very lucky. And our next speaker, anyway, and one we invited, our usual third Sunday. So please come to everybody because these people are leaders in our field. Today, we are so fortunate to have Kathryn Tucker, even though her voice is not too good. She is an outstanding lawyer in our movement and has been for, I'll say 30 years, but something like that. I think this is about the 200th time I've invited her to speak at one of our meetings. When I was head of the National Hemlock Society, I invited her all the time. And she always has something new and interesting to say because she's constantly doing interesting things with the law. She was, as you probably know, the legal director for Compassion and Choices for many years. She argued a very significant case before the United States Supreme Court. Was that 1987, I think?
97.
Yes?
97.
97. I was there. I've only been to the Supreme Court twice, one on the capital punishment case and one to hear Kathryn argue the constitutionality of assisted dying. Well, she can tell you what the outcome of that was. She's been head of the Disability Rights Center. She's founder and the executive director of the End of Life Liberty Project. She's taught at various law schools all over the country, and in New Zealand she's a Fulbright scholar. She has numerous publications, which are all very interesting. I've got a whole list of them in case you're interested. And she has worked in pain management. She's worked on psilocybin at the end of life. She was single-handedly responsible for getting the Montana law passed, which is different from all our other 7 laws permitting aid and dying in the United States. And there are accomplishments beyond the time that I have to introduce her, but you'd rather hear her, and she'll promise to speak up even though she's not in very good shape today, I'm sorry to say.
Thank you. Thank you so much. Hello, thanks everyone for coming out on a beautiful Saturday. I lost my voice completely. I was just, can everyone hear me?
Yeah.
Okay. I was leading a workshop down at Rancho La Puerta. Show of hands if you've been there. Ladies, mostly ladies. It's very lovely for men too. And I lead a workshop there called Preparing for the Final Asana, Law, Medicine at the End of Life, and what yoga has to offer. And it's the one time I bring my legal work in, interweave it with my work as a yoga teacher, and it's actually really fun. But I talked a lot and I also got a cold, so I have a terrible scratchy throat. Today I'm going to try to kind of do a bit of an overview, but drill down, because Faye asked me, into the things that are kind of on the cutting edge that I'm aware of and or working on, and give you a little bit of an insight on that. So I don't have a controller, but I guess Barry is going to advance the slides, and I have them here. So give me the next one. Yes. I don't need to tell an audience like this, but oh, I think I might have advanced 2 slides. Yes. We want one back. I think the reason why so many of us are here in this movement is that dying in modern America, for all of the wonders of medicine to cure and to prolong life that one wants to prolong, it sometimes prolongs the dying process so long that some patients find themselves trapped in an unbearable dying process. Atul Gawande is one of the good current medical writers on this subject. Many of you may have read his book on being mortal, and he kind of captures it, which is people used to die much more quickly, and now typically death comes only after a very long struggle. And so that's why we're here to talk about choices if that confronts you. Next slide. Why does it matter? I like to always remind us that for some people, having the last bit of their journey through this lifetime be coherent with what went before matters a lot. And probably if you're here, you're one of those people. This is what Ronald Dworkin had to say about it, and it's quite eloquent. So next slide, please. The sad news in some way is that there is a default in modern American medicine, and that default will always be in the direction of more interventions and more treatments, and a focus on the isolated crisis of the moment without the big picture in mind. In order to avoid that, to avoid stepping onto the conveyor belt of treatment, some really good planning and visioning is necessary, and learning is necessary. I've given you a title of a book that I read just before this trip that I read almost all of the books that come out in this field. This one I've given you, called That Good Night, Life in Medicine in the 11th Hour, is one of the best I've ever read. It just came out in 2019 by a young palliative care physician at UC, at Keck Medical Center. It's really excellent. And I think, she speaks very much to this issue and to this problem. Next slide. So everyone here will know, and I saw on the back table, there are some great basic planning tools. There is the advance directive, of course. Show of hands, how many people here have done an advance directive? Yes. Okay, so a lot, and that's great. When I ask my law students, I get like one. No matter your age, you should do an advance directive. So if Thanksgiving is coming up, which it is, and you'll have college student relatives at your Thanksgiving table, great time to talk about, have you done your advance directive? Because all of the cases in this country that are now household names, Karen Quinlan, Nancy Cruzan, Terry Schiavo, they were all young women in their 20s, and they all had a catastrophic event. They had not done a directive, and they ended up in a lot of conflict within the family and then within the court around should life-prolonging treatment be continued. So do an advance directive, whatever your age is, where you set out what your wishes for treatment would be in various situations if you can no longer make your wishes known. Nancy, who drove me over here, thank you, said, I think a lot of people will want to talk about advance directives for dementia. And when I was trying to make a quick exit to the ladies' room, one of the guests here said, could you talk about that? So yes, a newer tool in recent years is to have your advance directive address dementia. And for those of you who care about this, who have a fear that you might enter a state of dementia and someone will slap a feeding tube in, and then you'll live another 20 years. You can address that now with an advance directive for dementia. The two that I really like are from two different clients of mine. End of Life Washington has a good one, and End of Life New York has a good one. You may have a good one here on your back table. I don't know, I don't think I've looked at it. But the point is, you can address in advance, if I reach a particular condition, X, and X is whatever you delineate. Can't recognize my spouse, can't recognize my children, whatever. Can't do the New York Times crossword. When you get to X, your direction is, and then you can specify. And because we here are advocates for patient autonomy, your choice can go in any which direction. You can say, I want to be watered and fed into perpetuity. Or you can say, no food or fluid by any means. That means no feeding tube, and it also means do not bring the tray and set the tray in front of me with food and fluid. And do not approach my mouth with a spoon or a straw. Keep me comfortable. Do all the things that excellent nursing can do so that I'm comfortable. I don't have a sensation of cracked lips or dry, swollen tongue. Keep the tissues moist, keep me comfortable, but do not introduce food or fluid by any means. So yes, you can do that. One of the newer tools is the pulse. So for many years, those of us in this field were saying the wisdom of the advance directive. But then what we were seeing was advance directives were not being respected. So that's very sad and it's very wrong, but many times that happens. And to address that, the PULSE, the physician order for life-sustaining treatment, was developed. And the idea is the patient in discussion with the physician has the patient's wishes, which are probably also in the advance directive, reduced to a physician's order on a separate form, and that tends to get more respect because the physicians are the boss. So if you are seriously ill, the trigger for a PULSE is if you wouldn't be surprised if death arrived within a year, then that person should probably have a PULSE. So it's not for your 22-year-old grandchild at the Thanksgiving table. It's for someone with serious illness. A good development in recent years is we do now have reimbursement through Medicare for these important conversations. So your physician should be more willing to spend the time to have these conversations. That was a hard-fought battle, and I'm glad to say it's now compensated. Do you see my teacup? Teacup?
Oh, teacup.
Oh, here it is. Hold on 1 moment. Next slide. Slide. Okay. So I'll spend some time ticking through. So basically, for people who are approaching end of life with advanced illness, there are a plethora of choices. These choices that one can make will change what the journey looks like. A lot of the choices are not openly discussed, and the differences of what the experience will be not openly discussed, sadly. So informed patients can take a leadership role in talking to their clinician if the clinician doesn't initiate discussion about all of these things that I'll be ticking through on this next 8 or 10 slides. But in every state, stay with that one, in every state in the country, patients have the right to either reject on the front end or accept and then direct the withdrawal of any kind of life-prolonging treatment. And I've listed several. It is standard of care to have anticipatory palliative care. So if you're going to have a ventilator removed, palliation so there's not a sensation of suffocation. That is now standard of care. Do not hesitate to inquire whether your clinician is expert in pain and symptom management, also referred to as palliative care. If you don't have good confidence that they are expert, then bring in an expert. This is now its own specialty in medicine, and you want someone who's had a lot of training addressing your palliative care. It's its own board certification. Make sure the person giving you your care has the expertise that you will get outstanding care. Next slide. And this slide, very much speaks to, for patients in all 50 states, aggressive pain and symptom management is standard of care. So sometimes patients think, well, I'm here to have my cancer treated. I'm not really going to mention or bother the doctor about my pain. That is not wise. Having the clinician know and understand your pain and address it would be best advice. We do have a swing of the pendulum, and I'm sad to say that with the opioid crisis that has been besieging the country in recent years, the swing of the pendulum now, once again, is away from prescribing strong opioid analgesics. So you, as an educated consumer, may need to be aggressive in insisting on strong pain medication. And a clinician who is fearful of being scrutinized is not the clinician you want doing your pain management. Routine assessment and charting is standard of care, and then a response. So, there's the 10-point scale for pain, 10 unbearable, 1 low. If a patient is charting pain at level 7 and there's no response, that clinician is in trouble. There needs to be a response to a report of significant pain. And I have brought cases, and I've given you, for example, the case of Bergman up in the Bay Area, where an 85-year-old man dying of lung cancer was in hospital. He didn't get good pain medication. His family saw him suffering. He endured terrible suffering. And we did bring a cause of action against the physician for failure to treat that patient's pain, and we're successful. We brought it as an elder abuse cause of action, and had a huge jury verdict, which catalyzed clinician awareness and risk management awareness to the need to be responsive to pain. Next slide. So for patients who have pain that would be described in the literature as refractory, meaning it is not relieved with even state-of-the-art conventional pain and symptom management. And the literature on this says this might be anywhere from 10 to 50% of patients, so it's not an inconsequential number. All 50 states respect the right of that population to have the intervention known as palliative sedation. In the case that Faye mentioned that went to the Supreme Court of the United States in 1997, the Glucksberg case, companion case to Quill. Although the court did not embrace a federal constitutional right to aid in dying on that day, carefully reserving the possibility it might in future, but don't go to the SCOTUS anytime soon, given the changes on the bench. Very unhappy for civil liberties now before the US Supreme Court. That court did recognize that dying patients have the right to as much pain medication as they need to get relief, even if it advances the time of death, which was the court's way of alluding to palliative sedation. This intervention is provided by the physician intravenously. The patient is sedated to an unconscious state, so there's no awareness of pain or other distressing symptoms. Food and fluid are withheld until death arrives. That might be a couple of days, It might be a couple of weeks, depending on the patient's condition. But it is an option. Some people would think, well, that sounds barbaric. Other people would think, I could live with that. It's a good tool to know it's in the toolbox. This is also called lots of different things because clinicians are a little bit squeamish about this. It's also called terminal sedation, total sedation, and sedation to unconsciousness. You can Google it and you'll find lots of clinical practice guidelines. One of the things to be most aware of is when you start to look at those guidelines, you'll notice it is only for patients with physical pain. It is not for existential distress. So I'll talk about that one a little bit later. If the clinician refuses to tell the patient about it, that is actionable. And I've mentioned the case of Hargett versus Vitas, which was a case I brought also up in the Bay Area. I learned about this case because the Sacramento Bee published an article in which the mother of the patient, the mom was about 60, the daughter was 40, and the daughter was dying of pancreatic cancer, which is known to be very painful. And the mom and the dad had brought hospice into the home. Vitas, has anyone heard of Vitas? It is the nation's largest chain of for-profit hospice, and promised their daughter that she would not suffer because they had brought in Vitas who knew how to get the job done on pain and symptom management. Well, Vitas never told the daughter about palliative sedation, even though she fell clearly within the clinical practice guidelines. I learned about the case because the mom was interviewed in an article that I read in the Sacramento Bee, where she said the way she knew her daughter had died was that the screaming stopped. So we did bring an action against Vitas for failure to inform the patient about that option. Again, since we're all here today, all of you are now empowered with information, but about 20% of clinicians in reported study do not tell patients about this choice because they have a personal, moral, ethical, religious objection. So know about it, and if you happen to be that patient or the caregiver, ask about it, and if your clinician is willing, transfer care. Next slide. So in all 50 states, it is the right of the individual to choose to stop taking food and fluid. We even have an acronym, VSED, voluntary stopping eating and drinking. If you are going to make this choice, you should, it is advised, to bring in hospice, to have really excellent supportive care. Again, it could take anywhere from a few days to several weeks, depending on the patient's condition. And you want to be comfortable throughout. Sometimes your right will be obstructed. Not your right, because you are empowered and informed, but Dorothy and Armand Rudolph in New Mexico, they were both in their 90s. They had been married forever. They had complicated medical conditions, and they both were ready to achieve death. They told their very expensive assisted living facility that this was their choice. They got a 24-hour notice of eviction and a 911 suicide call. This is wrong. The children, who were in their 60s, flew in from out of state, took their parents to a VRBO, vacation rental, brought in hospice, supported their parents until they were able to achieve death, as was their wish. After the Rudolph case, I do recommend a couple of things. If you are shopping for an assisted living facility for yourself, or if you are the child of someone and you're helping them, ask these questions in the interview, on the tour, before you take admission. Do you support patient autonomy? Do you support the right of residents to choose to forego food and fluid? Would you ensure that if they take up residence here and they consider this their home, you wouldn't evict them if they were ready to achieve death by foregoing food and fluid? Would you support them in hospice coming in so that they could be comfortable? All of those questions, ask them way before you've moved in and taken up residence. Nobody likes to move, even when they're young and healthy. You don't want to have to do it when you're ready to achieve death. I do think you could try to negotiate a rider to your contract at your assisted living facility to avoid this situation of the Rudolphs. And that little rider would say exactly what I just said. It is agreed that this facility will support the decision of the resident when ready to achieve death to voluntarily stop eating and drinking. Okay, next slide. So everyone here, of course, knows about the choice for 8 and 9. This has been a long, hard-fought battle. California, I'm happy to say, in 2016, did bring into effect the End-of-Life Option Act. This is only for mentally competent, terminally ill patients who can self-administer the medication to achieve a peaceful death. Very widely supported. You'd wonder why it was such a hard-fought battle, given the public support, but very fearsome opponents. And so here we are. Next slide. Having been doing this work so stinking long, Faye, I'm happy to now be displaying this long list of states, all the way from 1994 in Oregon, 2008 in Washington, those states by initiative because no legislator would address this. Vermont in 2013 did traditional legislative process, as did California. The law passed in 2015, became implemented in 2016. Colorado, 2016 initiative. Hawaii, 2018. Maine and New Jersey, 2019. That's a long list for those of us who've been at this for a while. There are some states, and I've given you several, who do have statutes that specifically prohibit a physician prescribing medication for the purpose of a patient achieving a peaceful death. Next slide. All of these statutes impose significant limitations. So that's something to be aware of. I am really not a fan of the statutes anymore. I felt it was important at the beginning of this work. But you know, when we got to Oregon, we had already had a failed attempt in California, and before that a failed attempt in Washington. So each of those attempts just loaded on more restrictions. You can call it the kitchen sink approach. Every possible restriction was thrown into the kitchen sink, so that finally in 1994, Oregon would have a politically viable measure. But if you've looked at these statutes, you know they're chock full of restrictions and limitations and burdens, and it's really unfortunate. Next slide. Here we go. All of these procedures, multiple requests, oral and written, documented, witnessed, mandatory waiting period, 15 days, collection and reporting of data, opting out opportunities. I am happy to say that Oregon, this legislative session, did address the onerous 15-day waiting period. If the clinician thinks the patient won't survive, it can be waived. Hallelujah. In California, when the statute passed here, many of you may know of the work of Lonnie Shavelson up in the Bay Area. Maybe he's come to speak. His clinic is called the Bay Area End of Life Options. He sees probably more aid in dying cases in the nation than anyone, because he's one of those physicians that's willing to take referrals, and he's been very open about it. In his opening of that specialty practice in 2016, about half of his patients were dying during the waiting period. So here's another great piece of advice. If you think you might be a person who might want to exercise your right under the law to choose a more peaceful death through aid in dying, do not wait. Do not wait. There is no harm having your prescription or your medication in the medicine cabinet. And as you know, if you've taken a dive into the data, a lot of people get their medication and they don't even go on to ingest it. They're hugely comforted to have it. So don't wait. I've heard now way too many horror stories about patients who made their first request and then lost the ability to swallow before the 15th day. So act on this early. Some other tidbits of advice. Make sure your clinician is on board and is willing. I may say this on the next slide. I guess I don't. Yeah, so when you are being treated for advanced illness, your clinician may be squeamish about even acknowledging that you are with a prognosis of 6 months or less. They don't like to do that, so again, the informed patient must ask the clinician to please step over their squeamishness and be candid and honest about prognosis. The sooner the prognosis is given, the better for a host of reasons. One, another thing not to wait for, don't wait to enroll in hospice. The minute you are eligible, take that benefit. It's very rich benefit. You get comprehensive pain and symptom management, psychosocial support in the home. Unfortunately, too many people wait until they're in crisis and close to death. Early enrollment is best. Then you can call on hospice as much or as little as you want, but get it set up, take advantage of it. And so yes, having early conversations about prognosis, early enrollment in hospice, and the physician willingness to provide aid in dying. And have a very clear discussion. Don't settle for a discussion like, oh, if you're in discomfort, I'll take care of it. You know, the question is, would you write the prescription for the aid in dying medication? Yes or no? No waffling. So what do we know from the data? The data is so rich. If this topic interests you, and I assume it does because you're here, the data is so rich. When we were doing those cases in the Supreme Court in 1997, there was no data. So the terrible burden on the litigants was to respond to the arguments of the states. Danger, warning, without data. How can you combat speculation of danger when you don't have any data? It was impossible, and it was very impactful for that court. The great thing about the SCOTUS decisions is the court said, let's have the states address this in the laboratory of the states. How many of you here are lawyers? Okay, so you know, sometimes that's what the court does. Let's let the states address this. That's what happened in these cases. Well, the laboratory doors were flung wide open in 1997 because Oregon's law began to be implemented almost immediately after those decisions. Laboratory open, generation of data underway. And the data in Oregon has never been interrupted, although we've had to combat many attempts to roll back the Oregon or to nullify the Oregon law. We've been successful in combating those. So every single year, data is published, and it's very rich. So here's just a few tidbits. We know that most patients are dying of cancer. A next common diagnosis is ALS, because that's a really tough way to go. Most patients are a high number compared to general population or college educated, which also tends to mean they're more affluent. And here's a bit of a surprise, 90% enroll in hospice, which is great. Next slide. As I mentioned, many patients are comforted to get their medication and they don't ingest it. Something like 30% a year. Very sort of surprising, really, or maybe not, because humans cling tenaciously to life, but the comfort of knowing you have that option if things take a turn, very important. And then I happen to love the data that supports these contentions, which are unarguable. Physicians, when aid in dying is available, get busy learning how to treat pain and other symptoms. They take more training. They increase their prescribing of strong pain meds. They increase and make earlier referrals to hospice, and the communication between the doctor and the patient more candid and open. What does this do? It raises the floor for good end-of-life care for all patients who are with terminal illness, whether they want aid in dying or not. Next slide. And the data have also laid to rest many of the contentions about whether this would pose harm to vulnerable populations. It just has not been seen. That's good news. Next slide. This, I think, is so interesting. A researcher looked at what is the impact on family survivors of patients who choose aid in dying, and compared it to the impact on people who commit suicide, a phenomenon completely different from aid in dying. And the findings were starkly different. The commonly found horrific adverse effects on family member survivors of suicide were entirely absent in family members who survive a loved one who chose a more peaceful death with aid in dying. Those family members feel more prepared for the death. They felt that they supported their loved one, and their grief is more easily resolved. That's really important, and I happen to love that study. Next slide. So finally, we are now seeing broad support emerging among mainstream medical organizations. I've given you a few of them, and this is important. If you are an advocate, it's important and useful whether you're in the State House on a bill or whether you're in the courthouse arguing a case. This is the imprimatur of approval, the good housekeeping stamp of approval of these major public health and medical organizations. And judges and legislators, they're people too. And when they see support from groups like this, it's easier for them to support these choices. Next slide. Okay, so here's a little bit on the cutting edge, coming finally to some cutting edge. I hope I haven't been boring you so far. Here's the bad news, the sad news. Even in states, and now of course we're celebrating, there's so many, where aid in dying is openly legal. In addition to the many barriers I mentioned, there are other barriers to access. I'll mention a couple. Health providers opting out. this can happen across the range of the spectrum. So again, you as a consumer would be wise to inquire of your physician, and you'd also be wise to take a close look at where you receive your care. If you happen to be receiving care at a healthcare facility that is governed by religious directives, you may have constraints on the choices you can make. If you are of that faith tradition, that may be fine, and it may not bother you, and you may welcome that. If you are not of that faith tradition, you might be surprised to know how many hospitals and clinics are controlled by a religious entity. It's a very, very large percentage across the country, and in some communities, the only providers are religious. So be an informed consumer and investigate whether your clinic, your hospital, your nursing home, your assisted living facility, are they Seventh-day Adventist? Are they Catholic? If they are, they may not support your choice for aided dying. Some of you may have read about a lawsuit filed recently in Colorado. Colorado has a health system called Centura. Centura provides a huge percent of the care across the state. It is a hybrid Seventh-day Adventist Catholic entity. A patient who was receiving care there, who was dying of cancer, wanted aided dying. Colorado makes that option available. It is legal in that state. His physician was willing. So you might think, what's the problem? However, the physician was employed by Centura. Doctors, how many doctors are here in this room? Cautious by nature and training. So his doctor wasn't willing to go forward without knowing what would happen if she did. So she went to her leadership. They told her, no, we have a policy, it forbids it. But she said, it's legal in the state and my patient wants it. And I'm his doctor and I believe he should have this right. They said, too bad, our policy says no. So I, along with some Colorado lawyers, filed a lawsuit, and it ended up on the front page of newspapers across the country because when people take on the Catholics, it generates a lot of interest. She was fired the next day, and management showed up when she finished seeing her patients with security and took her badge and her computer and made her put her mug and her pictures in her box and walked her off the campus. And it was a very aggressive response. So that lawsuit will go forward. Colorado has, among all the states who have aided dying statutes, the narrowest opt-out, much narrower than any other state. And that opt-out in the statute only permits a provider to refuse to allow its physicians to prescribe for aided dying if the patient intends to ingest the medicine on premises. This patient did not intend that. So the opt-out is not availing for that Centura. However, they will be arguing First Amendment freedom under the federal Constitution. For those of you who are lawyers and who have been following the terrible reality of who now sits on the United States Supreme Court bench, very hostile to civil liberties and very overly respectful, in my humble opinion, of the Catholic perspective. It would be terrible if this case went to the Supreme Court of the United States. So I hope it doesn't. It is an employment law question now because with the firing, it is a wrongful termination in violation of public policy sort of a case. And I hope it will remain in federal court, although, in state court. Immediately the other side moved for removal to federal court, and that was one of the first battles. It's now back in state court. It's very scary to be in federal court these days because of what's happened to the federal bench under this administration. All right, also on the cutting edge, I represent veterans. How many people here are veterans or care about veterans? All right. Did you know that in the state of California, if you are a veteran and you reside in one of the CalVet homes, which run from San Diego to Napa, they're all over the state, and you want to choose a more peaceful death through aid in dying, you will be evicted. You'll be thrown out. Your home, where you live and you intended to live, because they provide 5 levels of care: residential living, assisted living, dementia care, skilled nursing, and hospital care, you'll be thrown out on the street. Well, here you are, imagine this. You've come to the place in your illness where you think your best choice is to achieve a peaceful death, because the cumulative burden of suffering is so great that you're ready to achieve death. You'll be evicted. Or you'll just be denied your lawful right that other Californians who didn't serve their country to defend their liberty. I'm not a veteran, but I have a soft spot. People who dedicate themselves to protecting the liberty of others, shouldn't they have at least as much, if not more? Shameful. So we have sued CalVet, and I'm very sad to tell you they are fighting this lawsuit tooth and nail. But we are trying to compel the court to have that regulation revoked so that a dying veteran who lives in a veteran's home can have the right to aid in dying under the California law. We were supposed to, and actually sometimes the universe is good. When I left here, I was supposed to fly to SFO and drive to Napa to argue this case, but with my voice like this, I'm very grateful that hearing got put over until February, when I expect to be fine. But I was sad it got put over because one of our clients has already died. Because, terminally ill people, they're in a dynamic process. They don't have the luxury of time. So CalVet asked for an extension, they got it, and we'll be hearing that case in February. All right, next slide. Okay, so Faye was kind enough to mention Montana. It's the one state in the country where aid in dying is openly practiced without a statute. So think about that for a minute. So for those of you who are clinicians, and several of you raised your hands, let me ask you to raise your hand again. If ever in your medical practice you opened up a statute, it just doesn't happen. It's completely aberrant, which is part of the problem with these statutes. And it's part of the reason why doctors opt out, even if they don't have a religious objection. They don't want to bother themselves to read the statute, and they don't want to bother themselves to follow a law in the delivery of medical care. In Montana, we took a case through the state courts to the Montana Supreme Court, and we won a victory there in 2009. And I just came from a really lovely conference in September celebrating 10 years of open practice in Montana with aid in dying not governed by a statute. And I should say, not restricted by a statute. So it has the court decision which says basically, if the patient is mentally competent and terminally ill and self-administers the medication, the physician can provide that to the patient. We did see legislative backlash, and so there have been efforts to enact a statutory prohibition, but those have been combated, and so all of those efforts were defeated, and the practice goes forward. And really, practice there is governed more like normal medicine, subject to standard of care. Next slide. I'm sad to tell you, and Faye always says nice things about me, but I don't always win. Sometimes I lose, and I'm sad about that. And I have a number of cases where I was a big fat loser. We did try to bring cases in Alaska, New York, and New Mexico through the state courts where we made state constitutional arguments. And I'm really sad about those losses because it reflected a kind of a timidity by the state high courts that should be concerning to the citizens of all of those states. State high courts are meant to step up and enforce their state constitutions, which are often much more protective. It didn't happen in those states. Next slide. Now this is a super fun thing, cutting edge, that I'm very fond of at this moment. And I work with a really wonderful colleague organization in North Carolina called Dying Right North Carolina. I don't know if you know of them. I know Ed loves you, Faye. Ed Turiakian. He's like, oh, you're going to see my friend Faye. Ed, like Faye, goes to all the meetings. Ed Turiakian is the president of Dying Right North Carolina. And he came to me about a year or two maybe ago, and he said, we want to pass an aid in dying law in North Carolina. And I'm like, Ed, you're in the Bible Belt. Are you on crack? I mean, the chance of that seems vanishingly small. The good news, though, is I did a deep dive into the law of the state of North Carolina, and I was able to come back and say, Ed, I have some good news for you. You don't need to pass a law in this state, and you don't need to bring a lawsuit because the state of North Carolina is one of a handful of states where there's no prohibition. There's nothing on the law books that would prohibit the practice of aid in dying in the state of North Carolina. There's no assisted suicide statute. There's nothing. There had been an attempt to pass such a law, and it was defeated. Even better. They tried and they lost. The landscape is clear. And there's a lot of law in North Carolina that respects the rights of patients to make end-of-life decisions. So I said, with this landscape of law, clinicians who are willing to provide aid in dying in North Carolina can do so right now. So I published, as I like to do, and Faye was kind to mention, a law review article in the North Carolina Law Review that goes through every bit of this law, this landscape, making the conclusion that there's no possibility of exposure for a clinician who provides aid in dying, so long as it's subject to standard of care. And what do clinicians look to? They look to things like clinical practice guidelines, journal literature, the conduct of their peers. So there's plenty of that available to help a clinician know what standard of care is. So I hope that starts to unfold in North Carolina. And I did find 4 doctors who were brave enough to write an article that they published in the North Carolina Medical Journal that says, hey, check it out. There's no barrier in North Carolina. And we doctors who believe this is something our patients should have, we can get busy educating ourselves about aid in dying and providing it. So I hope that starts to unfold. And I'm happy to share with you this slide because aid in dying is now so mainstream, and the practice spans the country from Maine to California, that my friend Lonnie Shavelson, who I mentioned who runs the Bay Area End of Life Options. He's been a real powerhouse, and one of his things is he's convening this major national conference for clinicians. So if you're on the speaking tour, which I've been on and off for too many years to count, usually at these big national conferences, it is going to be a parade of lawyers, sometimes a parade of bioethicists, sometimes a smattering of doctors. But this conference, look at its title, National Clinicians Conference. They are really working to have no lawyers, no bioethicists, just the doctors, right? And let's bring them together from everywhere and get busy educating doctors on best practices, right? When I was in Montana, I was kind of sad because even though we won that great victory in the court, and even though we were there to celebrate 10 years, it was still in the closet. We did find a small cohort of physicians who were brave enough to come and sit at the podium in front of an audience and say, yes, in the last 10 years I have been providing aided dying, and here's why, and here's what my experience has been. But they were very closeted. It is time to take it out of the closet. It's long overdue. And I think that this conference will help the clinicians across the country feel like, whoa, I'm not ashamed. Look at me at this conference with 200 of my peers from all around the country. So I do think that's going to be a great event. And non-clinicians can go. And I think they have, opportunities for people to have tables. And maybe, Faye is such a powerhouse. I expect to see her in the lobby with a table representing hemlock. Oh, you go, girl. All right, next slide. So I mentioned this only in passing when I said palliative sedation is only for people with extraordinary physical distress. What about people with extraordinary non-physical distress? My new friend Nancy, I know you think about that. Many of you may be either social workers or psychologists or psychiatrists where your work has been addressing non-physical distress. That's been, in my mind, as a lawyer, so who am I, but in my mind, it's been a gap in the palliative care toolbox. The thing I'm really excited about, psychedelic medicine. If you've been following, anyone here a Michael Pollan fan? If you've read his book, How to Change Your Mind, or before his book, he had a great article in the New Yorker called The Trip Treatment. He's been studying and writing about the cohort of clinicians and researchers who have, and look, there's some people here older than me who may remember the 60s. Who remembers the 60s? I feel, okay. So Timothy Leary, Richard Alpert, the Harvard Psychedelic Club. So they were doing all of the early research. They got a little too enthusiastic, perhaps, and they were dosing their students, they were dosing themselves, they were going to raves, and what happened? It got shut down. And it got shut down in a very aggressive way. All of those substances got put on Schedule 1, which means the most restricted schedule under the Federal Controlled Substances Act. No one can prescribe them for any purpose whatsoever. They're deemed to have no legitimate medical purpose. The research ground to a halt, but these very tenacious researchers over the last 20 years have been doing very careful, rigorous studies. Johns Hopkins, UCLA, UCSF, NYU, those are the big research institutions. And they are now almost to the end. And the studies are finding quite remarkable efficacy of even a single session of psychotherapy assisted with psychedelic medicine eradicates anxiety about terminal illness for people who had refractory anxiety. I've been blown away by the studies. So, a tremendous groundswell of excitement is coursing through the country. And if you haven't been hearing about it, you surely will. Oregon has an initiative on the ballot for psilocybin, magic mushrooms. California has, of course, many interested entities. And so there's a lot of groundswell, and advocacy efforts are getting underway across many communities. The thing I think that is a little bit tricky, enthusiasts in their enthusiasm are sometimes not willing to limit their enthusiasm to medicinal use. So the measure in Oregon, for example, is not so limited. And I feel sad about that. I'm disappointed because I think medicinal use is an easier first step. And there's a serious need in the patient population. And I think that the recreational use could have followed later, just like happened with cannabis. So I have some mixed feelings about some of the measures coming forth. But keep an eye on that. And if you haven't read, I'll put in the plug for Pauline's book, How to Change Your Mind. It's pretty amazing. Oh, here we come to the end at last. I just throw up a few of these predictions. I do think we'll continue to see choices expanding. Aided dying will continue to be increasingly available. We'll see new palliative tools like the psychedelic medicine. And I think, and I hope, normalization within the practice of medicine of aided dying will start to unfurl. And then I must invite you to like and follow the End of Life Liberty Project. If you don't know us, you can follow us on Facebook. I would be remiss if I did not invite you to make a large donation. Faye, of course, is always generous in leadership on that. But this work cannot be done without the support of people who care about it, and enough said there. But that last line is my email. If you'd like a copy of the slides, please.
Question. Our next speaker is going to talk about the law in Canada. We seem so far behind. How are we ever going to catch up with voluntary euthanasia and less restrictive requirements and not just doctors doing it, and all these things that they have just north of us?
Right. So yes, and Canada does have a much more progressive regime. I don't know that we're going to catch up. So Canada, you may remember the case of Sue Rodriguez back in the early 90s, which took to the Canadian Supreme Court the question of whether this was protected by the Charter of Freedoms, which is their sort of similar in scope and effect to our federal constitution. And the court said no. But then much more recently in the Carter case, the court said yes. And the court said yes in a very sweeping and broad way. So in Canada, the condition of the patient need not be terminal. It is grievous and irremediable. So that can be a much wider scope of patient. And the patient need not self-administer. So it's much more progressive. You know, I don't see the support for that in the States. You know, the evolution in our federal judiciary has been very, very dark in these last 3 years. I've mentioned that several times. It's just very dark. And the judges that were appointed are very young, and they'll be there for 50 years. May we all say a prayer for RBG, that Ruth Bader Ginsburg, who's now, I think, 85, keeps doing her plank in her fitness class, because, you know, if there was the chance for another seat to be filled in this administration, even worse. But it's been almost a quarter of the lower court seats have been now filled by this administration. So I don't think any of us can look to civil liberty protection in the United States Supreme Court. I mean, if any of you care about LGBT issues, thank goodness the Lawrence and Obergefell decisions came out before this bench changed and established those rights. But everything is at risk now, and these times are very dark, sadly. Other questions? Yes?
Does the Medicare cover the medication, the right?
For aid and dying?
Yeah.
The question was, does Medicare cover medication for aid and dying? So no. There is a statute that was enacted by the federal legislature right after Oregon's law was passed, called the Federal Assisted Suicide Funding Restriction Act. No federal funds of any kind are to be expended on assisted suicide, which of course, as smart as you all are, you know that aid and dying is no kind of suicide, and it's not assisted suicide, but it is understood to be that. And so no federal funds. So it would need to be state or private funding.
And are there, like if a person's interested in that, are there places that can help with that, foundations or anything? Or, I mean, I don't even know what the cost is. I think it's just a couple of bills, right?
Yeah, so I mean, that's a great question, and the next time you have a clinician speaker, take that up with your clinician speaker. I'm not that knowledgeable, Faye may be. I think the prices have fluctuated a lot with what happens with pharmaceuticals. And so the clinicians have been super creative in finding different mixtures to address cost. And again, like Lonnie Shavelson, I think, at the Bay Area End of Life, is very on top of what is the most current, efficacious, and inexpensive mix of medicine. So I think he'd be a great resource on that. And I'm sure that will be talked about at that conference. Yes, Wayne, in the back.
I have ALS, and I've talked to my physicians about this, to my neurologist, and I followed what you said to say, do you have any ethical problem with this? And he said, no, I can do this for you.
Oh, thank you. That's what I need. I'm not enough. So anyway, it was very interesting, but I also get the sense from reading multiple things that he can make a diagnosis in 6 months, and there's nobody checking on the back end that you died within 6 months. There's nobody in the living room with your family to make sure you took it yourself. It's a front-loaded system. There's nobody from the state that's going to monitor this entire process. They make you jump through hoops, but if you, and I'm going on Tuesday to make my request again. I made it twice with a witness. They sent me to the top of the palliative care doctor, and I'm going to make my case there again with a witness, and I'm going to take something in writing. I don't think it's necessary for me to go in every 3 or 4 months and say, now am I 6 months from dying?
Right.
Now am I 6 months from dying? And you know what? My doctor agreed with me. They said, can we just skip that part? I'll have it in the house.
Right,
No one's going to go check. Nobody's going to come after you. No one cares.
right.
So
Yeah.
I think that there's a lot of fear in the front end, but if you step by step and you have a physician, I know I need a second physician to agree. And is there not a concierge physician in the Hemlock Society or Compassionate Choices that will sign off? I think there is one.
Yeah, I mean, I think, first of all, I think it's great that you're so on it so early, to be commended. You know, the physicians are only in the safe harbor if they comply with the statute. So certainly they are going to be sensitive to a supportable, defensible prognosis of 6 months or less. But there's no reason why you can't get it on day 1 of 6 months. And I think everyone does acknowledge that prognostication has some squishiness to it. So I do think, yeah, it sounds like you're very on it with that doctor.
Or no one, it doesn't matter.
Yeah, but it matters for their feeling safe. One thing I will say too that I'm happy to say about ALS is, I listed some of those groups that are coming out of the closet in support of aid and dying, and I have started to see ALS societies come in as amici, friend of the court, in the various cases I've had. And that's been like pulling teeth, but we're finally getting them to participate. So for any of you who work with ALS Society, encouraging them to be advocates for the patients they care about so that this option is more widely available is a really great service. And yes, just working hard to get that prognosis as soon as you can, and then get the prescription as soon as you can, and make sure you're through all that process as early as possible.
We do have a local aid and dying doctor, Bob Ruslander, who's spoken here several times. Thanks to Ken Watson, our programs are videotaped, or whatever you call it these days, and they're on our website, thanks to the work that Pat Fisher has done and Greg Knox. So I think there are at least 3 or 2 meetings that Bob has spoken at, so you can see him. And he's here in Del Mar, so you don't have to go to North Carolina.
It's Bob Uslander, U-S-L-A-N.
Integrated MD Care.
Yeah, he has a nice website. I think he might be on the expensive end of things because he is, as you alluded, a concierge physician. But yeah, he's a resource. Yes.
I was recently updating my advanced directive to reflect my
Can you hang on until we get a microphone, Pete, because other people like to hear your questions.
Can everybody hear me now? I was updating my advanced directive to reflect a new primary care provider. We actually talked about death with dignity. Well, I was surprised when California passed that. I said, I'm glad, because if I ever become a shell and I have Alzheimer's, I don't want to continue that. It's a waste of financial resources. I'm a shell. Well, when I was looking at the frequently asked questions, it expressly prohibits anybody with dementia or Alzheimer's. And I'm thinking, well, I want to consider this to be preemptive. And what you described was that you could withhold food or water by any means. Is that how?
Yeah, so the more modern advanced directives for dementia, and I mentioned 2 of them that I recommend. One is on the website for End of Life Choices Washington, and the other End of Life Choices New York. They're both very good. And maybe, does your packet here, Faye, have an advanced directive for dementia?
Yeah, I think it does. We have to update it.
Okay.
Actually, Final Exit Network, Rob Rivas is working on one too.
Okay. So you can address that in your advanced directive. I think the tricky thing is making sure that everyone in the circle of caregiving is on board. So making sure that the nursing home or the assisted living facility or the clinic or the clinician, touching base that they are all on board, and if they're not, transferring care early so that you know. I also, and I hate to say this, but I'm almost to the point of recommending a new paragraph in an advanced directive. And that's because just recently I consulted on a case where an elderly man in his 90s had done his advanced directive with his son, who is an advanced care planning professional. So that's a rare amount of expertise to have in the family. And he had done everything just right. And he had said no life-prolonging treatment. And then he had a crisis at his nursing home. He got transported to hospital, and he was subjected to life-prolonging treatment, and in violation of his directive. And I've seen a lot of those cases, but this one just was like the straw that broke my camel back. And I just now feel, although it might be a little too aggressive, that in your directive you might include a paragraph that says, my wishes as expressed in this directive are profoundly important to me. I am directing my surrogate to hold accountable to the maximum extent of the law anyone who violates them. Just to say on the front end, if you don't honor my wishes, they're going to come after you for accountability. It's just so sad. And there are lots of theories, by the way. So, not that you would ever want your wishes violated, but if they should be violated, your survivor should pursue either a battery, a medical negligence, an elder abuse case. There are lots of theories that lawyers can work with to impose accountability. And I think those cases must be brought.
Our directive in Hemlock used to say, my estate will not pay for any treatment beyond that which I request or don't request.
Yes, there you go. Turn off the money.
Yeah.
I've heard the argument about, we euthanize our pets. What's the argument against 89? What do you hear most often?
Well, I'd be here all the rest of my next 30 years.
There's like one default that they use a lot, or is it every state's different?
There's the religious community objection, which is sort of the easiest to put to the side, but it's very vocal and powerful. There is a disability community opposition, which I think is very much now undermined by the data. But you certainly saw aggressive opposition, and you continue to see disability rights groups opposing legislation and filing briefs in court cases opposing court decisions that are respectful of patient autonomy. So, it has been a wide range of opponents. I think it's narrowing, but the opponents are well-funded and very aggressive.
Yes, the California law has been on appeal. Now it's back in the trial court. Is there going to be an actual trial in that case? Do you have any prognosis on what's going to happen?
Well, the challenge to the California law, there have been challenges to pretty much all of these laws, and none of them have succeeded. But it does require the long slog through the courts. I think at the end of the day, what's likely is the argument that has caused the cases that challenge the law to fail has been that the parties trying to strike the law don't have standing. The argument has been that any patient who doesn't want this isn't going to choose it, and any doctor who doesn't want to provide it isn't going to provide it. So when organizations or doctors or patients who are opposed come into court, it's pretty easy for the court to say, you don't have standing. The courthouse doors are not open to you because you would never choose this. So that's how most of these challenges have been thrown out. But it takes a while. Fortunately, the California law has continued to be implemented.
You know about Final Exit Network. We've had several programs here on that organization as an alternative. We have some literature in the back. Dr. Sally Hall is here, who has spoken to us before about Final Exit Network. Look it up, Google it. It's a national organization that does not use a medical model. And I've always wondered why it's so important to have a medical model, but that's beside the point, since I was the founder of Final Exit Network. But it's a different model.
And it's free.
You don't have to be terminal. People come to your house, there's no charge, and there's no drugs. So we will do another program on Final Exit Network sometime next year. But until then, check it out, talk to Sally, and talk to us. We know all about it. We hope to inform you.
One more question or so. I know.
What do you think is really underneath the Department of Veterans stance?
Well,
Is it financial? What do you
yeah, as I mentioned, that federal statute that says no federal funding. So when CalVet saw the enactment of the End of Life Option Act, someone noticed that federal statute and then noticed that, well, CalVet gets about 20%, somewhere between 20 and 25% of its budget from the federal government. Now, something around 75 or 80% is non-federal. So I say they have an accounting problem. Simply get out the pointy pencil, anyone here an accountant? And figure out how to make sure no federal funds are expended. It didn't want to do that, it was too lazy. It was just a laziness and really reprehensible. So I hope at a minimum what will happen with that case is the court will say, you need to go through the exercise. They didn't even go through the exercise of examining, could they segregate funding? And I think the answer at the end of the day will be yes, they could, and just expend non-federal funds. But you know, it is true, it's a lot of money. It's something like $67 million a year. So, you know, you don't want that money to stop flowing, but I think it could have been preserved with a less draconian measure.
It also means that doctors who practice at VA hospitals cannot use the end-of-life option either, right?
Right, if they're using federal funding.
Well,
So,
they're
you
paid
know,
by the-
again, it would depend on if there is a segregable funding so that they could be giving their care with non-federal funds. So I'm gonna thank everyone for having me, and I'm so sorry that my voice was, those of you who've seen me before, this is not my normal thing. Apologies.
No apologies.